Welcome to Silberman Law Firm's Weekly Docket, Episode 2, where we talk legal news and practical law. Today is January 26, 2024. I'm Phil Silberman, your host, and I'm here with my co-host, Austin Black, out of our Dallas office. How are you doing today, Austin?
Doing fine. A little bit under the weather. Just took a test and confirmed I had COVID, but we're gonna make it through.
We're doing a COVID show.
Exactly.
Austin's a trooper. So the main goal for episode 2 is not to offend as many people as we offended in episode 1. I think we offended Italians, Canadians, everyone who leaves online negative reviews, convicted felons, and people that failed the bar 5 times. And it turns out that our producer, Aaron, is Canadian, so there's that too. Weekly Docket. What's on our docket today, Austin?
The Supreme Court razor wire case involving Texas attempting to protect its borders.
All right, SCOTUS, borders, and razor wire.
Exactly.
Got it.
And then Apple Watches have been banned again. So we're going to talk about that, and then we're going to answer a few legal questions touching specifically on non-compete Airbnbs and them being restricted as a result of deed restrictions, and then suing fraudulent adoption companies, something I hope most people do not have experience with. And then we'll do the rants and raves section, talking about small business regulation.
That's one of my least favorite things is regulation. I will be doing a lot of ranting about 1099s and other oppressive things for small businesses. And it turns out we've got securities filings for small businesses that may or may be required.
Yeah.
So that's our show. Let's get kicked off with our first segment, legal news. So we've got the SCOTUS Supreme Court United States razor wire case. Now, here's the facts on this thing. The Texas law enforcement, National Guard, whatever, who controls our borders in Texas with Mexico, goes and throws a bunch of razor wire, primarily along the Rio Grande. The Biden administration doesn't like it. So they sue the state. It's just, you got to let federal agents remove the razor wire. Why is the razor wire a problem for the Biden administration? I personally think the optics are bad.
Sure.
It's one thing if you've got cartel members with tatted up faces trying to get over the Rio Grande, which, by the way, I don't think they go with the Rio Grande. I think they have tunnels to get the drugs in and all that kind of stuff. The optic of maybe pregnant women and children getting caught in razor wire is kind of a cruelty, inhumane type of thing. Now, I don't know whether that's really happening, but I'm certain that the Biden administration, the Democrats, are alleging that's a possibility. But razor wire might be a good thing for keeping cartel members, might be a bad thing for people that are sympathetic to the immigrants getting caught in some razor, which I get. So what's Texas's argument here, essentially? Why do we get to put razor wire down and patrol our borders?
So Texas is allowed to defend its border under Article 1, Section 10, Clause 3 Constitution.
You've got the United States Constitution, and the idea is the federal government has to do its job and protect the states.
Yes.
That was part of the deal, and our framers ultimately put that in the Constitution.
Which is in Article 4, Section 4.
And then in their wisdom, they figured maybe the federal government might not always protect the states. So in the event the federal government fails to do its job, then the states can take it upon themselves to protect their borders. And that is Article 1, Section 10, Clause 3. And that's the letter that Governor Abbott penned to the Biden administration. And I think he hand-delivered one of them anyway.
He did say
that's
that.
the argument, why we get to do this.
Yeah, and Ron DeSantis apparently sent National Guard members to Texas too, so we'll see exactly what they're going to do, but yeah.
And I heard that was a result of former President Trump basically called on as many governors as possible to send National Guard to support Texas. And I want to say something, 24 governors either have sent or have agreed to send National Guard to Texas to protect our borders. So that's wild in its own right.
It is.
We're in Texas. Most of us in Texas want to protect our borders. The bad news, when I saw the letter, is the letter cited the dissenting opinion that was issued by Justice Scalia in the Arizona case back in 2012. So we're basically, Governor Abbott, our governor, is basically citing and deferring to a losing horse, right? We've lost this one. So we're gonna take the same horse,
Sure.
losing horse, and ride it again.
And it was so strange to me. Of course, I know it's political grandstanding, but just Abbott 100% knows that you can't cite a dissenting opinion as legal precedent.
You can cite a dissenting opinion if you want. It's not very persuasive.
No, it's not.
Now the good news is that was 2012, and the Supreme Court is a lot more conservative now after all of President Trump's 2016 appointment. So we've got that going for us in the state of Texas.
There's definitely the chance they could just overrule that specific holding. They could, but I don't know. So
now here's some other interesting news. After the Supreme Court, by the way, did not issue a full opinion. It was basically just a ruling, like a 2-sentence ruling. And the Supreme Court said, okay, federal agents, you're allowed to cut away the razor wire. That was the extent of the ruling. So some very smart people in Texas decided that that's a very narrow ruling. So just as the federal agents are cutting away the razor wire, we'll send our law enforcement agents just to put it back. So I have this visual of these guys on the Rio Grande. The feds are out there laying down razor wire, and our federal agents are like, I always imagine the Texas Rangers, right? They get some Texas Rangers cowboy hats, and like putting the razor wire up after the feds,
yeah.
To me, it's the height of ridiculousness.
Yeah, it's like that scene from The Simpsons where the dude's throwing the guy out of the bar, and the guy comes up right behind him after he throws him out, and he has to throw him out again. Yeah, it's the same thing.
So that's what we have. We have a Simpsons episode going on.
Yeah.
Okay, and on the Texas-Mexico border right now. That's where we are. Let's see where this goes. This case is ultimately not going to be the greatest, most interesting border case, I don't think. We'll see if the Supreme Court ends up taking it up for to actually issue a proper opinion, or whether they take up another border case, or what happens with that. Let's talk about something completely different than Texas borders, which is Apple Watches.
Sure.
Do you have an Apple Watch?
I do have an Apple Watch.
Okay. I have an Android.
Okay.
And apparently my family hates me because I have Android. At one point they sent me a meme that says, when you have an Android, you're hurting your other family members.
Yeah.
And I guess it's because my texts are a different color or something like that. Now, my wife is an iPhone, and she has this Apple Watch. And by the way, this thing, she just got a new one, and I think which is the big one? It's one of the ones, the Series 9 or Ultra. I don't know which one. The thing looks like a laptop on her wrist. So this is the kind of watch we're talking about. And as part of these watches, specifically the Series 9 and Ultra 2 Apple Watches, Apple decided they wanted to put a blood oxygen reader, an oximeter in the watch. And the fact you have COVID is perfect for this piece, because when we all first got COVID, like years ago in 2020, we all decided that we needed a bunch of oximeters. And after you get the sniffles, at least I did, because I'm a hypochondriac.
Sure.
I'm like, okay, maybe I've got an upper respiratory thing. Where's my oximeter? What's my blood oxygen level? And if I dip below like 97, which is very high, by the way, I'm like, or 90, I'm going to the hospital.
Yep.
That's how we do it. But so Apple decided people wanted these oximeters on the watch. These two watches had oximeters on it, and apparently the patent was owned by another company, and I don't have the name. I want to say it was like Moss or something. Massimo, is that right? Fight against Massimo.
Yes.
That sounds weird. Wasn't Massimo like some shirt brand in the 90s? But I don't know.
I would not know.
You might be you may be too young for that. But as my generation, maybe I think we had some Massimo clothing, but I think that's the name of the company that had this patent for this oximeter. So Massimo sues Apple and says, hey, you're violating a patent. Apple probably knows they're violating it. I don't know, but Massimo wants a ton of money for the oximeter, and the two of these companies cannot come to a deal. So it was like on again, off again, a customs or border or whatever. They decided, okay, you can ship them in, you can't ship them in as it stands now. No, if you want Apple Watch with an oximeter, you're not getting one, because they can't figure out the thing. And if you bought one and or has the oximeter, you can keep it. Don't worry, the patent police are not going to come and take your watch.
Hopefully not.
But if you're looking to buy a new one, Intel, Massimo, and Apple do a deal, no dice on that, okay?
Yeah.
All right, let's answer some legal questions.
Yeah.
The first one, what's the first question we've got today?
Yeah, so we've frequently had people reach out to us to ask questions about non-competes.
The guy's saying, all right, is my non-compete still enforceable if I'm fired? I guess that's funny because it's attorneys, it's maybe obvious that your source of term or your reason for termination or separation may not be material to whether your non-compete is enforceable. And just to make this hit home a little bit, you can take a job on day 1 or 2, sign a non-compete, get fired the next day, and it could still be enforceable.
Yeah, absolutely.
The way these things work is you get hired by a company. Day 1, you get the agreement, the employment agreement, and these non-compete clauses have to be part of an ancillary agreement, which is the employment agreement. And then the non-compete clause recites certain consideration, and that consideration is typically the trading of confidential information. So if you were fired on day 1 or half a day, did you really get the consideration to make your non-compete enforceable? But yeah, non-competes are pretty rough thing. They're in New York, by the way. I saw an article that they're thinking about saying, I think it was $200,000 or under, you can't be subject to compete. We do a lot of non-compete work at our firm, and we often represent employees, and those things can absolutely be enforceable. And we've seen them create absolute hardship on families and employees that sign these things. And most of the time, the guy wanted a job or the person wanted a job and wasn't thinking, signed it. What does it mean? And they got into an enforceable non-compete, and that was their livelihood. Okay, what's our next question?
So HOAs, frequently homeowner associations, like to restrict people from operating their properties that they own in the HOA as Airbnbs or short-term rentals.
I've got a friend, okay? He's a buddy of mine, and we're a member of this tennis club, and we're in the locker room, and he's like, Phil, you got to do something for me. He lives in the Galleria area in Houston. And he says, Phil, I live in this townhome, and my wife and I love it, and we've loved it for many years, but in the last couple of years, we've noticed that it's been rented to out by the night on Airbnb and VRBO. And he said, Phil, what happens is these young people, they come in from all over the country, and a lot of them are professional athletes and their entourage. And he says, they go to these clubs on Westheimer, and then they come into my townhome community, and they have these crazy like sex parties, and they're doing drugs, and there's girls walking around in thongs, and they don't ever go. And the after parties from like 2 a.m. to 6, 7, 8 in the morning. And my wife is just beside me. You got to help me, Phil. And I'm like, all right, let's take a look at the deed restrictions. And sure enough, the townhome community was built before Airbnb, or I don't know when they're 90 or 90, whatever, before Airbnb. And it's got some really generic language in the restrictions that say these townhomes you're not allowed to use for commercial use. You're only allowed to use these for residential use. And my response to him, that's not going to get the job done. Unfortunately, why I don't agree with it, doing drugs and having sex parties and sleeping and eating and girls walking around in thongs, those are all kind of residential.
All residential activities, normal residential activities, yes.
Residential, not a commercial activity. So we can't rely on your deed restrictions alone. We're going to have to change the deed restrictions. The problem is, okay, when we change the deed restrictions in Texas, you usually need a 2/3 vote, and it's a cumbersome process. So yes, we can go change the deed restrictions. And then if we do that, we go through that process, then we can specifically say no Airbnb, no VRBO, no short-term rental for less than 30 days. And then we can get rid of all the after parties that are spilling over from Westheimer and Richmond, and his wife can sleep and doesn't have to worry about strippers blowing coke in the driveway. Okay.
Good solution.
That's how we do that. What's our next question?
This couple paid an adoption agency a little over $12,000 to do the whole process, and this little girl, and they go through the whole process, but then the mother of the little girl shows up and says that she wants the child back. And so that's a happy story, but the adoption agency does not refund the couple any of their money that they paid.
Adoption fraud. We have an adoption fraud ring.
Exactly.
Circulating somewhere in Texas, which is absolutely despicable. It's legal fraud occurring. And it's criminal, by the way. We're not criminal lawyers. We're civil. These people, of course, file a complaint with the district attorney and see if they pick it up. But the scheme that you're describing, where the ringleader meets some unsuspecting family that wants to adopt and says, hey, we pay a $10,000 retainer for these adoption services and we work these hourly rates. And then they get to the very end and all of a sudden the ringleader calls up and says, oh, I'm so sorry. We were so close, but the mom, the birth mother showed up and wants to keep the baby. And the parents, being good people that wanted to go through this job, oh, we understand. And yeah, I'm so sorry about your 10 grand. We worked so hard on almost making it work. We can just keep on and do it next time. That happened 3 or 4 times until I think people started talking to each other. They started getting wise and they realized that it was the same birth mother, like showing up or something. That's how they got caught. And then all of a sudden, these parents are just beside themselves. We've been defrauded by this ring, and you've got 4, 5, 6, 7 families that have been defrauded, and maybe they call us. And what do we do? Yeah. And we have a lot of these sad conversations. It says, okay, well, yeah, and they feel wronged, and yes, we can sue them for fraud. Do we have this in our show notes? What's the first element of fraud?
It needs to be a material misrepresentation.
We've got material misrepresentation, right? I represented I had a child for you to adopt, and there was never a child. Yeah. What's the second element?
Misrepresentation has to be made knowingly or recklessly with knowledge of its falseness.
Absolutely. This was just a complete fraud, knowingly made a fraudulent statement. What's the third element?
The intent of that misrepresentation must have been to induce you to act in a certain way.
Yeah, I wanted to induce you to give me the 10 grand retainer.
And then justifiably, you act on that misrepresentation that was false, and that causes you injury.
Okay, so the family paid the 10 grand, were defrauded, lost the 10 grand. So you've got this, you've met your elements for civil fraud. Yes. You hire us, we go into court, we prove it all up, and then the clients are over there, yeah, we've won. The problem is, now how do we collect? Let's say we get a judgment for the 10 grand plus attorney's fees plus punitives, and you get $100,000, $200,000 judgment, and your client says, where's my money? Yeah. I say, the person who defrauded you is actually in prison, been ordered to pay restitution, and they're absolutely penniless. So you've paid us all this money to get you a judgment on paper that's completely worthless. It's just tragic, but you don't want to throw good money after bad money, hiring an attorney to go after a penniless client.
Yeah, I always tell potential clients who are in that situation that even if they get a judgment like this, the judge doesn't have a pot of gold behind his desk, so he's not going to be able to give that to you.
And I remember one time I heard a judge who behind his bench says, everybody come around here and look, there's no magic cash register back there to pay after judgments. I just have a pen. And all right, next on our list, I think we've got a war story. So you only hurt yourself when you lie to your lawyer.
That is true. Don't lie to your lawyer. Don't lie to your doctor. We'll find it out eventually.
We get a lot of potential clients that call us up and they want us to take the case. So they're making their case sound better than it actually is. And I'm not going to say they lie. They maybe just omit some material facts, right? And I always tell them in the consult, look, tell me the worst things first. Okay. Tell me what I'm going to deal with. Don't trick me into taking your case, because ultimately you're paying my hourly rate. You're doing yourself a disservice if we don't have all the bad facts.
Yeah.
We ask this to every client before we put on the stand, which can be a little bit offensive, which is, now, Mr. Smith, you're not a convicted felon, are you? Well, why would you ask me this? Well, so we were trying this case. We were doing a little, it was actually a temporary injunction hearing, and we put Mr. Smith on the stand on direct, and he thought we'd done this wonderful job on direct, and then up comes opposing counsel on on cross. First words out of opposing counsel's mouth is, Mr. Smith, isn't it true that you're a convicted felon? And we're like, it could be one of these where we put our head down as let's see what he says. And Mr. Smith is, I'm uncertain whether I'm a convicted felon. And opposing counsel is, now that's a new one. What do you mean you're uncertain? And he got up there and he hemmed and hawed for like, finally the judge was so pissed off. All right, everybody up here to the bench. Counsel, take Mr. Smith back there and see if he can figure out whether he's a convicted felon. So we take Mr. Smith back and we're like, Mr. Smith, are you a convicted felon? And then we say, look, we're going to make this real easy. Okay. Can you own a gun? All right. Can you vote? And then when we asked it like that, we decided, I think Mr. Smith became sure that he was a convicted felon when we like, don't lie to your lawyer, because we could have handled the were you a convicted felon question a little bit better if we had a heads up.
It's a lot easier to do damage control if you know there's damage.
Let's rant and rave a little bit. And the first thing we were ranting and raving about is oppressive small business regulation. So this is a topic that's very near and dear to my heart as someone who's owned many businesses and has been tasked with doing all the regulation. Austin, I know you're one of our many attorneys that work at the firm, but you probably don't realize how I labor behind the scenes, keeping us in compliance with things like taxes and trust requirements and insurance and all kinds of things the government oppresses me with, right?
Mm.
All right, so you form LLC. We form LLCs. You form some LLCs for people. And most of the LLCs we form are for small business owners. Usually a couple of guys that want to go buy their property or whatever. And we can't figure out, and this is when I say we, as far as I know, all the attorneys out there representing small businesses, we are incredibly uncertain as to when that small business owner is going to need a securities filing. Nobody knows the answer to this as far as I can tell. For example, if you're going to raise a bunch of money in the public and you're advertising and you're going to say, hey, to random people, give me $100,000, give me $10,000, whatever, that almost certainly requires some type of filing. Now, the other end of that spectrum is you and your wife or a close friend start an LLC to buy real estate property and it's all your money. Certainly, you don't need a filing for that.
No.
But then you have everything in between. Right? What if you ask for your brother-in-law for some money? Or what if like one of your friends, and does that require a filing? And we've never been able to figure this out as best I can tell. And I've asked numerous securities lawyers. I've got another friend of mine that he went to Harvard and he's a securities lawyer. And I sat him down and I'm like, hey, can you tell me when a small business needs to do a securities file when they're forming an LLC? And he probably talked himself into circles for 5 minutes. And by the time he was done, he forgot the question he was answering. And you just don't know. So I got so frustrated with it one day. And I said, I'm going to call up the Texas Securities Board. And I waited on hold for about an hour with the Texas Securities Board. And finally, I got an attorney for the Texas Securities Board. I said, hey, I'm a small business law firm. We represent a lot of small businesses across the state of Texas. And I've asked several securities lawyers, and we all can't figure out, can you give us some guidance on when small businesses forming LLCs need to do some sort of securities file? And she talked a little bit. She said, and then she started to whisper. And she said, Mr. Silberman, I'm going to tell you a secret. And I said, okay, finally, this woman at the Texas Securities Board is going to impart this amazing wisdom. And I've got my notepad ready. And when are we going to do a file? And she says, Mr. Silberman, here's the secret. They're all doing it wrong, but we just don't enforce it until they do something really bad. And then we just tack it on for fun. Okay, that's awesome. So what you're telling me is every time my clients form an LLC, or most of the time, it requires some sort of filing, but nobody ever does it. But if any of them go to steal and cheat a bunch of people, then you just tack on the penalty for good measure. So
that's at least good to hear that clarity from someone in government. So
I'll tell you how we handle it at our firm anyway, is if it's just beyond a single member LLC, we're not securities lawyers. I have to tell you to go get a securities lawyer. Nobody ever does, but I have to tell you to go get one and check to whether you need a filing. And they're like, how much is a securities lawyer? They're like $2,500 an hour or something. that.
Yeah.
And they're all like, no, thank you. All right. And our final example of government oppression is, and you may not know this, but this is one of the things I supervise at our firm, is we are in 1099 season. And 1099s are informational returns that small businesses have to file, typically hundreds of these forms every year. If you're a small business and you pay vendors throughout the year, you have to, if you pay them over $600, you have to report how much you've paid them, and you fill out a form, you give it to the vendor, you give it to the IRS. And that is the primary way that the IRS catches the small business owners underreporting or not reporting income. The whole system, as a matter of fact, is based on small businesses snitching on each other. That's the whole system. And what happens is if that guy doesn't put it on his income tax return and you file it, then the software is going to match it together, and that's how it's going to trigger an audit for that person. So the whole system is snitching. Now, in the old days, we would generally try to comply, but do you know how much the penalty was in the old days? And I know because you're looking at the show notes, but how much the penalty was it was $15. Yeah. You failed to file a 1099, $15. Today, that penalty is $630. And oh, by the way, that's not actually the maximum penalty. And I don't know how they do this. I guess the IRS and their administrative code says, all right, but there's no maximum penalty. So the minimum is $630 for intentionally and willfully not filing a 1099, but we could potentially find you more if we were really mad.
Always good to have options.
1,000, 2,000, 10,000, there's just no cap.
Yeah.
That's not the worst of it. In order to file these returns, you have to use this system called FIRE. And I think that's the most, I don't even know what it stands for, but if doing taxes aren't stressful enough, the IRS wants you to use a system called FIRE.
Yeah, of course.
And the system, by the way, was designed like in 1996, and it looks like something from the MS-DOS era. And you have to have this proprietary file, and it takes forever. Half the time it doesn't even work. Okay. And here's my favorite part of the whole 1099 process is once you have all these businesses and once you get to the end and you send it to all your vendors, hundreds of forms, and hopefully you got all of them. Maybe you didn't because you break out into a cold sweat because the IRS is going to fine you a gazillion dollars and try to say you intentionally disregarded the 1099. So you get to the very end and you're filing your tax return. And if you have an S Corp, it's an 1120S. If you have a C Corp, it's 1120 or whatever it is. And the IRS, and by the way, they're sneaky snakes is what they are. Okay. The IRS updated the return, I don't know, 5, 6, 7, 8 years ago. And they put this one little line in there and they say, has the corporation or will the corporation file all 1099s required? And they ask you as the president or the vice president or the CFO, whoever signed this return, it wasn't enough to fine us a gazillion dollars. They want us to sign a statement in this return under felony penalties of perjury that we filed every 1099 so they can send us to prison if we don't. That's the type of tax burden that our government wants to put on us.
Sounds about right.
And that's what that's what we're doing. That's what all small businesses are doing this time of year that is our tax system at work. And by the way, here's a quick tax tip. If you want to avoid doing a bunch of 1099s, only pay your vendors with credit cards, because if you pay your vendors with credit cards, then the credit card company takes care of filing the 1099 and then you don't have to. So that's a little tax tip.
It's a good workaround. Yeah.
Good workaround. So I think with that brings our show for a close. I appreciate you hanging in there with COVID and doing what you can with the show.
Yep.
I know
of course.
Our listeners and fans will say you were amazing.
I'm sure.